So now that we have heard from all today's speakers, we will move on to the discussion session. In the discussion, particularly in sub-theme 1, I'd like to ask the speakers some questions. The first one, I understand in Japan and Thailand, trademark and copyrights are often the basis for customs suspension of the imports. Mr. Kansko, cannot Royal Thai Customs suspend pirated content in the basis of the patent or other intellectual property rights in addition to copyright and trademark? That's a question for you. And on the other hand, Ms. Yokogoshi, could you kindly share the specific examples of design infringing content and unfair competition prevention law cases injuncted at the Japan Customs?
So in Thailand, as I have already mentioned that as of now we are protecting to our kind of copyrights, that is trademark copyrights. We are ourselves, right? We are law enforcement. Like we have to listen to the policy side, which is the Department of Intellectual Properties. Having said that, like if the question was, would there be like any expansions of rights to be protected at the border in the near futures? There might be possibilities, big possibilities that we can include some other intellectual property rights, such as, for example, GIs, like geographical identifications or industrial designs in the futures. Like I can't really say more about that because that's on the policy side. That's what I have heard, and it's a big trend. It's like we call it TRIPS plus, not just only trademark and copyrights, but for patents, I think I am certain that is some things that we have to talk about it. Like not in the near futures that that patent will be included for border protection because it's very difficult to verify the infringement of patents in the shorter period of times, like, and then considering that like you have a very certain limit of time for the goods to be released by customs. So I think that the big things like we have to talk about again in the future. Thank you.
Thank you for the questions. So regarding design acts, there are some suspension cases such as electronic devices, including earphones, and some household appliances, including kitchen utensils. And regarding the unfair competition, there are a few cases, but the example is some scalp brush that causing confusion by using well-known trademark.
Thank you very much, Ms. Yokogoshi and Mr. Kansko. So, there's a second question. In the Philippines and Thailand, there were the significant suspension result in 2023, in my understanding. But the number and the value of suspensions have declined over the past 2 years. So, Ms. Patilaya and Mr. Kansko, is there any reason for this?
Thank you for the question, Yabe-san. So, if we still remember the table that I've showed you a while ago, there was a decline in the number of seizures. So, in 2023, we have 268 number of seizures, as opposed to only 16 number of seizures in 2024. However, the value actually increased. So in 2023, it was only 25.37 billion, while in 2024, it was 34.69 billion. So one of the reasons why there was a decline in the number of seizure cases is that it's also the effort of the Philippine Customs. So we actually strengthened our border protection, especially in airports. So in 2023, most of the apprehensions were in the Clark International Airport. So as we also know that in 2023, there were more air travelers because of the COVID restriction. So there's no longer travel restrictions during that time. And in 2024, there was a decline because of strengthened border protection by the Philippine Customs. So I hope that answers your query.
This is a very difficult question, and I think there is no one fit all answers like for me, for myself, right? But speaking from a criminal justice perspective, right? You have many crimes, like the trend of seizures increase. You can it somehow means that you have more crimes in your societies. On the other hand, like if the number of cases decrease, it doesn't really mean that you have an effective enforcement procedures in place. Like in fact, you have to look at the actual or situation in the societies. Like, but for me, like one of things like the things that I have already like observed personally is that there's a trend. The consumers like behavior in Thailand for high street brand is decreasing to some extent. You can actually see those Louis Vuittons, Christian Dior's, or bags, with high street, with high value brands, selling only in Thailand at the touristy markets. Some things like patong, some things like siloms, like, but we don't have them selling on the street sites like for Thai or nationals. Or I don't see people are what do you call, like they I don't see people wanted to buy that or acquire the sort of things. Like we have like alternative brands like that they can identify themselves instead of having to carry Louis Vuitton bags. That's one of my observations. Thank you.
Thank you, Ms. Fadriaya and Mr. Gansako. So in the Philippines, the Philippine customs is now successful on the high-valued things they're suspending. And also in Thailand, maybe the people are getting wealthy so much. And so then the behavior would be changing.
Yeah, because most of the apprehensions in 2023 was from the airport. So because we've actually strengthened and we became stricter when it comes to the border enforcement in airports, less air travelers bring counterfeit goods, like hand-carry goods. Yeah.
I think in Thailand, if you look at the sale volume of Uniqlo or Muji, I think they are increasing, not declining. So.
I'm happy to hear the Japanese brand growing in your country. Thank you very much. As a last question, as a third one in the subsim one, I understand also that in Taiwan, it seems that many of the suspended items are disposed of. Then I just wondered who is responsible for the disposal and how is it carried out with some funding. Something in the Thailand?
By law, for example, customs, we can dispose infringing items ourselves. Unlike in our European countries or in Japan's, that you can ask like for budget from right holders or exporter importers. Like in Thailand, they are crimes. Like importing or exporting infringing items, they are criminal offenses. So in that sense, it means like we have to prosecute importer, exporter, and we have to seize the items. Once the items were seized, like they belong to the state, like they belong to the governments. Is our responsibilities. Like it's a big burden. I don't say that this is good models, right? But it is what it is, right? It's a since they are crimes, like since like they are state offense. If they're state offenses, like and we have to be burden of the disposals, then it's like it's our burden to dispose. The thing is like we don't do it every single month or single week, or we do it occasionally. It's like based on our budget, like, and we have to do it like several times a year. Otherwise, like we don't have enough space for other contraband items to be stored like in our warehouses.
Thank you very much again, Mr. Kansako. Then now let us move on to the topics of the sub-theme 2. So as a first question of this discussion, in Indonesia and Malaysia, site blocking is already widely implemented. In Singapore, there are also court orders restricting users' access. In Mr. Varen's slide 19 and 21. So, Mr. Varen, can we understand that the Singapore system for the copyright infringement serves a similar purpose to site blocking? Is it correct understanding?
Yes, that's the correct understanding. And it performs the same function as a site blocking order. But I would like to think that in the wisdom of our parliament in legislating for this new law, it was deliberate to name this mechanism as one that is meant to take action against a flagrantly infringing online location. So it's not merely restricted to websites. That is absent in the language, and I would say that it would apply to any form of online infringing location, social media, SNS, marketplaces. So it does seem to have a wider effect than purely confined to a website.
Okay. Thank you very much, Mr. Varen. It's a good clarification. And as a fifth question about still on the site blocking, Mr. Roman, are you still online? Mr. Roman and also Mr. Nizam Biharil, do both of your countries believe that restricting the distribution of infringing content through site blocking does not infringe on any rights? For example, the secrecy of the communication. Is it correct understanding?
First, normative perspective, and secondly, practical perspective. In normative perspective, we have a legal basic to conduct site blocking and restricting of the distribution of infringing content. And we conduct the cooperation between Ministry of Justice and Ministry of Digital if we find sufficient evidence. So we believe that the blocking website is not, it's not infringing the right of the other people, and in the practical perspective, there is an interesting thing. Yeah, I mean, when we blocking the infringing content, yeah, no one of the owner of the infringing website make a complaint back to us. Yeah, that's be an answer that the content, for sure, it is the infringing content gitu. So if the owner have argument their website or their content is not is legal, we conduct like a normalization process. We can normalization the website to the normal condition.
Actually, Malaysia recognized the secrecy of communications because before we do the site blocking, even though we have a provision under the Act 522 under section 263, section 2 of the MCMC, we do have to make sure that we must ensure that before we submit the email or letter to instruct the ISP to do the site blocking, we need the evidence from the right owner, because they have to submit the evidence and the documentations and the proof, the investigation. They already investigate, do the proper surveillance to the websites before we submit to the ISP. This is to make sure that under the email, under the letter, we will stipulate what are the provision under the MCMC Act, what are the criminal offenses under the Copyright Act or Trademark Act, and also what kind of the names of the website. Because in Malaysia, when we do the site blocking, we block the site, the website, yeah, the whole website. So meaning to say that if we have certified with the evidence, with the proof, the investigation done by the right owner, only we can submit the letter to the ISP to do the content removal. So we do respect with the secrecy of communication, but in the copyright, we also must be fair to the creator, to the any who create, who give ideas. You know, they have their investment, so we should respect their rights in terms of property, their property in terms of copyright and trademark. That's why if the site blocking is not to suppress or to limit the expression or to limit the secrecy of communication. What we want to do is prevention, speed, and the protect of the IP rights of the trademarks and the copyrights owners.
Thank you very much, Mr. Rahman and Mr. Nizam bin Halil. I think this discussion would be quite good reference for our Japanese discussion regarding site blocking in future, I think. So as a last question for Mr. Nizam bin Halil, so regarding cooperation with platform providers, it seems very important for the enforcement agencies to build relationships that helps restrict and distribution of infringing contents. So referring to your slide 13 and 14, what is the Malaysian government's main effort in building such cooperative relationships?
Yeah. We have a very strong engagement and collaboration with the enforcement agencies and industries in terms of government agencies like MCMC and also like the industry like the CICO program, who do have collaborations whereby, I mentioned earlier, that through the MCMC using their act, their legislation, that enable us to instruct, to control, to prevent any sharing, illegal or infringement of copyrights or trademarks in their websites. But also I would like to share with you a cycle. In Malaysia, we have a special program which we protect, we encourage the local film makers before they release their films in the cinema, also on digital platform. They need to inform us within 7 days prior to the release. They register with us, and upon receive the letter complaint from them, we will approve their join to the program within 14 days, starting from the first day of release of the films we will disseminate and we will instruct all the ISP, the telcos companies to do the site blocking or content removal within 14 days. Because normally we have in Malaysia, we have problem after the first day. The first day of the launching of the film in the movie, in the cinema, also the platform, digital platform, there has been sharing and disseminate in the, in the public, to the public. That's why, for the foreign movie, we do the procedure whereby we can do the site blocking through the MCMC. Yeah. So we have two types of program whereby we can deal with the local films, also with the foreign film. Thank you.
Thank you very much, Mr. Nizam bin Khalil. So now, as we have heard many interesting presentations, 2 hours have passed quickly. We would like to express our sincere gratitude to all the speakers for sharing valuable experiences from their respective countries. And we also extend our heartfelt thanks to all distinguished guests, participants, and viewers of this session. So we hope that the wealth of the information shared today will contribute to international cooperation in addressing intellectual property infringement on the Internet. Thank you very much for your kind attention.
以上でパネルディスカッション、知的財産権侵害への対策に関する各国の経験の共有を終了いたします。ご登壇の皆様、ありがとうございました。